I'm Russell Alexander. Welcome. How Ontario family law cases can differ from those that simply involve families. Two recent decisions highlights the difference between Ontario courts' jurisdiction when it comes to civil matters that happen to be a dispute between a parent and child versus a family law matter that involves determining the best interests of a child. Important distinction. In the first decision, two parents bought a cottage in 2001 for $150,000, but registered title in the name of their adult daughter. They also registered a mortgage in their own favor for $175,000, which was to cover the full purchase price and some intended improvements. Unfortunately, the father died in 2009, and around that time, the mother registered a second mortgage on title for $350,000. The mother and daughter eventually had a falling out. The mother started a court application asking the court to declare that despite the daughter's name being on title, the mother was the cottage's true owner. The trial judge determined that the parents' intent in 2001 was to gift the cottage to their daughter. The daughter appealed successfully to the Ontario Court of Appeal. The appeal agreed that the trial judge's decision should not have taken the liberty on ruling on the mortgages aspect, since that wasn't an issue that had been placed squarely before the trial judge. It was unfair to make a ruling when the daughter had not had a chance to make submissions on the issue of the mortgages. This outcome is in contrast to the second decision we're going to talk about today, Jones versus Jones. There, the family court declared itself eligible to make a ruling about child support that neither parent had technically asked for. In Jones, the mother had abruptly left the father and relocated the children to a new community without telling him. This prompted a series of orders to force the return, some of which the mother ignored. To force the child's return. One of the issues on appeal was whether the trial judge had erred in unilaterally making an order for child support that reduced the amount of the father's support payments when it was not sought by either party under provincial family law statutes. Nor was it in keeping with the requirements of the federal child support guidelines. The Court of Appeal dismissed the appeal, finding that the trial judge had not overstepped her mandate and was authorized to rule on the issue of child support, even if it was not asked for. This was because the judge was empowered to do what was needed to achieve the best interests of the children. The trial judge was entitled to make the child support orders ancillary to the custody and access issues that were squarely before her. The Hobson and Johns cases reveal an important distinction in how Ontario courts approach their judicial mandates. Hobson was a civil case that happened to involve family members, while Jones was a case that triggered the application of the family law statutes, which specifically designed to foster and protect the interests of family members, most notably the children. Look for our blog where we talk about these cases in more detail. You can like this video, you can share it. Please leave your comments at the bottom. We will try to answer everybody's questions at the end of the week. Thank you for watching today.